Yes, Ms Finnis.
Thank you, Your Honour. I understand that we have Mr Chico, Deputy Secretary of the Department of Justice and Regulation, Principal Legal Policy Officer. Can you both hear me?
Yes, we can. Thank you.
Thank you. Mr Chico, perhaps you'd introduce yourself and the department.
I am, as you noted, Deputy Secretary of Criminal Justice within the Department of Justice and Regulation, and I'm here with David Joyce, who is Principal Policy Officer within our Victorian Government Coordination Unit for implementation of the Betrayal of Trust report, our Parliamentary Committee of Inquiry report, and to coordinate in response to the Royal Commission's activities. I'm here just to speak to the Government's response to the Royal Commission's recent consultation paper on redress and civil litigation.
Thank you. I invite you to speak to your submission.
The Victorian Government's submission to the Royal Commission's consultation paper effectively just draws the Commission's attention to our Family and Community Development Committee of the Victorian Parliament's inquiry into the handling of child abuse by religious and other non-government organisations, a Betrayal of Trust report, which was tabled in November 2013, and that report reflected upon a range of issues attendant upon the child abuse by such organisations and made a series of recommendations. A number of those recommendations are relevant to the Royal Commission's Redress and Civil Litigation paper. We have noted in the Government's response that Recommendation 28.1 from the Betrayal of Trust report suggested a government-run Victorian redress scheme for victims of child abuse in an institutional context. The Victorian Government has previously indicated publicly and in discussions with the Royal Commission that we are progressing work on options for a Victorian redress scheme and that we propose to publish a consultation paper in the near future with some models with respect to a redress scheme, including that which was recommended by the Betrayal of Trust report, which was an extension of our Victorian Victims of Crime tribunal arrangements. We have also, in the submission, recognised the important work that the Royal Commission is doing, and the Government has indicated in the response to the Royal Commission that the Government would be happy to work with the Royal Commission in the context of future recommendations it may make in respect of redress. With regard to some of the civil litigation recommendations, with regard to the civil litigation issues in the consultation paper, we have drawn the Royal Commission's attention to the fact that we have recently introduced into our Parliament reforms to the Limitation of Actions Act 1958. Again, the bill addresses the recommendations of our Parliamentary Committee of Inquiry, which effectively address both prospectively and retrospectively the removal of the 12-year long stop limitation period for wrongful death actions in relation to child abuse brought by defendants of a deceased, as well as in the context of actions for personal injury to a person resulting from child abuse. I believe we have subsequently forwarded that bill, explanatory memorandum and other materials to the Royal Commission.
Thank you. Is there anything further you wish to say?
Nothing at this stage. We would be happy to take questions.
Thank you. Mr Joyce, do you have anything you wish to say?
No, thank you.
Okay.
Can I start by saying you give us a problem, and I'm sure you appreciate that, and it's not your fault, but as you told us previously, the Victorian Government is, with your assistance, working towards designing a redress scheme which will be, I assume, a state-based scheme. Is that right?
Yes, correct, Your Honour.
And of course, as you know, the overwhelming response of survivor groups and major institutions is that there should be a national scheme. You understand that too?
Yes, I do, Your Honour.
How does your government see the work that you're being asked to do fitting in with a national scheme?
Your Honour, this has been subject of discussions at previous roundtables. We are progressing this work, notwithstanding our acknowledgement that the Royal Commission and a number of institution and victims groups would prefer a national scheme. We are mindful, however, of the circumstances of other jurisdictions and some of the discussions that have been engaged at some of those public roundtables that have been chaired by the Commission. This work will be of use in a Victorian context, as we have been examining a number of the issues that the Royal Commission draws out in its consultation paper. If in the event that a national scheme or some sort of national arrangement cannot be progressed for whatever reason, we would argue that the work that the Victorian Government and a number of our departments are working with us in that regard. This is not just Department of Justice and Regulation, but we would argue that such work could then be utilised in the establishment of a Victorian scheme.
That's undoubtedly true, and thank you for saying that. But does that mean that the Victorian Government hasn't turned against participating in a national scheme if that comes about?
I think our submission made it clear that we would be willing to engage with the Royal Commission and with other governments in the discussion of a national scheme, if that be the preferred method. And as you note, Your Honour, a number of the victim survivor groups and organisations have indicated that that would be their preference. But should that not be practical, feasible or supportable by all jurisdictions, then we do have an obligation to implement the Parliamentary Committee of Inquiry's recommendations.
One of the fundamental issues that those who support a national scheme identify is that there should be consistency of response, irrespective of the institution and its geographical location. And I assume that the Victorian Government would accept that, if possible, that consistency of response should be provided.
Indeed.
Yeah. Now, I know you've got a discussion paper coming, and forgive me for pressing a little harder, but our work so far, and can I express at this stage again our appreciation for the contribution which you have made on behalf of the Victorian Government to our roundtable processes. It's been very useful. But we have identified three significant components of which you're aware as being the foundation for an effective redress scheme. Is there any mind in the Victorian Government to suggest that there are things that we've missed in terms of components, or that the three we've identified aren't appropriate?
We wouldn't dispute any of the issues that that the Royal Commission has noted in its consultation paper, and indeed a number of the issues have been the subject of significant discussion amongst government departments and agencies in our consultations. The only thing I would draw to the Royal Commission's attention, I guess, is that our betrayal of trust report did recommend that the Victorian Government utilise the existing Victorian Victims of Crime Tribunal as a fora for the redress scheme. That would be the only point of difference, I guess, in our considerations vis-à-vis those articulated in the Commission's consultation paper.
Yes, I appreciate that. That leads me then to ask, has your thinking matured, and maybe it has, to what should be the standard of proof before a person becomes eligible for benefit under a redress scheme?
I suppose I would cast it in the context that our consultations have reviewed a number of the issues that the Royal Commission articulated in the consultation paper. In whatever is produced by Victoria by way of a consultation paper, we will be detailing a number of the issues that have been canvassed in the Royal Commission's consultation paper. Our discussions with a number of groups here in Victoria have suggested the same issues that the Commission has articulated. It depends very much on the structure of the scheme, the nature of the eligibility, the scope, etc. But we would agree the plausibility threshold that has been indicated in the Royal Commission's consultation paper does seem to be supported by a significant majority of stakeholders.
What's the current standard of proof in the victims of crime legislation in Victoria?
It's a civil balance of probabilities threshold.
That's a significant step from plausibility, isn't it?
It is indeed.
Yeah. Very well. And the process there, is that a formal process that involves lawyers and hearings and examination of witnesses?
It can be done by way of a paper-based approach, or it can involve lawyers and witnesses. It does depend very much on the claim and the circumstances.
Thank you. Can you tell us when you think your discussion paper will be out?
At this stage, we are planning around late May, early June, but of course that will depend on considerations by our Cabinet and Government. We, of course, have an acute interest in seeing it when it emerges, given when we're going to report, you understand? I do appreciate that, Your Honour.
The other issue I just wanted you to help everyone understand, Victoria has adopted a particular approach to civil claims. I think they're referred to as guidelines in relation to sexual assault. Can you help everyone in this room and those listening to understand what that might be all about?
I think it would be fair to say that Victoria has, for a long period of time, adopted a model litigant approach to the settlement of civil claims. They do go beyond claims of alleged sexual abuse, but also into alleged physical abuse and other harms. The model litigant policy, now replaced by the common guiding principles in 2014, essentially provide a settlement process wherein people can apply for particular, in respect to particular claims. The guide provides approaches in a way that is consistent and appropriate process for the making of child abuse civil claims, and that makes it less litigious. It minimises the potential further trauma to survivors. It reduces our reliance on legal mechanisms, and it ensures greater consistency in dealing with claimants. And it also provides, includes the provision of pastoral letters, apologies. In some cases it has involved visits to particular institutions, the provision of certain documentation that individuals may not have in possession but have desired. We have, those principles are available on our website, and the key areas wherein the claims arise largely in the context of our Department of Health and Human Services and Education and Training, each individually manage their civil claims in respect of those guidelines. So does that mean if I was suing the state because I was involved in some commercial dispute, compared with suing the state because I was sexually abused, the litigation process would be a different experience in the sexual abuse case as opposed to the commercial case? Is that what it comes down to? We would follow different guidelines in each, but the model litigant approach applies in our commercial matters as well, but it would be a fair thing to say that the common guiding principles for responding to civil claims alleging abuse are far more targeted at, I guess, the care of the victim in those circumstances.
We know, of course, of what your government has done in relation to the statute of limitations. But one of the issues which was, of course, identified in the Ellis case and which was discussed by your parliamentary inquiry is a body to sue in relation to an unincorporated organisation, which arises in relation to the Catholic community in a number of respects, not all, the Anglicans and various other institutional structures which don't provide a defendant or a defendant with money who you can sue. Have you made progress in resolving those issues which, let me hasten to add, are not easy in their resolution?
We have been examining it from a range of perspectives. We haven't progressed it to a point where I could articulate any specific consideration of solution, but we certainly are examining it. As the Commission is aware, our Parliamentary Committee of Inquiry suggested a range of potential solutions, including using existing tax exemptions as a means to encourage organisations to
do it themselves.
Yeah. Indeed.
Carrot and stick. Well, some organisations, and indeed some spokesmen on behalf of those organisations, have said the organisation should respond. As I understand it, the Anglican diocese in Victoria have moved to respond. Are you familiar with what they might have done?
We've had discussions with representatives of the Anglican diocese. I haven't had any more recent discussions in that context, but I know they were moving to form some sort of entity that might assist in that process.
Of course, I suppose one way of dealing with it is to take away, either voluntarily or otherwise, a capacity to defend on that basis, but that raises complex issues.
It does indeed, Your Honour.
Will your discussion paper in relation to redress attempt to discuss these issues as well?
No, not in the form that we're considering at the moment. That will be probably subject to further considerations. As the Commission is aware, our Parliamentary Committee also made recommendations with respect to vicarious liability, and we thought we'd deal with some of those civil matters together in a later paper.
Do you have any idea when that paper might become available?
Judging by progress at this stage, Your Honour, I'd have to suggest either very, very late this year or early next calendar year, that is.
Right. So you can expect legislation to go through and be operative in relation to the statute of limitations, but evidence otherwise in relation to statutory action in relation to civil liability otherwise may be some way off.
Indeed.
Yeah. Ms Finesse, do you have any questions?
Just one matter, if I can, Your Honour. You've indicated that you have the common guiding principles. Do those principles come into effect when a claim is made by way of an allegation in writing, or do they come into effect when proceedings are instituted in court?
No, generally speaking, these arise in the context of an allegation made in writing. In the main, we have a range of legal firms here in Victoria which have generally assisted claimants in this regard, so generally some process or filing does occur concurrent with that application being made.
Concurrent with, does that mean that the principles generally and largely apply when a claim has been made in the court processes?
They can apply otherwise, but the practice has generally been, just to clarify.
Thank you. Thank you.
Deputy Secretary, it's Commissioner Murray here. I have one question for you. In the absence of a national scheme, there may be populations in Victoria who would not qualify for a Victorian redress scheme. Is it your intention in your proposed discussion paper to identify those populations which would fall within your scheme, but those others which might not and would otherwise might be valid for a national scheme?
Commissioner Murray, were you intending those victims who that wouldn't have been captured in the original Parliamentary Committee of Inquiry report? Were they the groups you were thinking of?
Well, I'm not sure. I'm really asking you whether there will be people who would otherwise be would otherwise fall within a national scheme that may not fall within a Victorian scheme, who are resident in your state.
Oh, I see. That would be true. We had worked on the principle that the redress scheme, if it were a Victorian-only scheme, would capture those victim survivors who had been subject to such alleged sexual or physical abuse within a Victorian institution of some sort, government or non-government. So it would not capture those who might be now resident in Victoria that may have been subjected to such harms in another jurisdiction.
Thank you.
Can I finally ask you, does Victoria support a national scheme?
Well, as indicated in our submission, Your Honour, Victoria would be prepared to engage in discussions with respect to a national scheme, recognising that there would be advantages to a national scheme from the perspective both of organisations and victim survivor groups, for all of the reasons that the Royal Commission has articulated in the consultation paper. But again, as I noted earlier, if that proves not to be practicable or feasible, we do feel obliged to continue with the work in the context of our own Victorian scheme.
Yes, Justice Coate has a question.
Mr Chair, just one question. In answer to Justice McClellan's question about plausibility, I thought you were indicating in your answer that plausibility, the test, the standard of proof, seems to be supported by the majority of stakeholders. But are you meaning to tell us that it's also supported by the Victorian Government?
At this stage, Your Honour, I couldn't say that definitively. What I would suggest is that, as the Royal Commission has noted, and indeed as we've reviewed some of the submissions to the Royal Commission's consultation paper and our own investigation of international schemes, dependent upon how the scheme is structured, dependent upon the scope and how extensive the compensatory amounts might be, it may be that a higher threshold may be necessary in respect of the structure of the scheme. So I guess I would suggest that we will likely provide a few options that may consider plausibility as well as higher thresholds.
Your difficulty, of course, would be feeding it into victims of crime legislation if you change the standard of proof, but that's an issue that no doubt you'll address in due course. Yes, well, thank you both, and can I again thank you for the work that you've done with the Commission in helping us to develop the ideas in our papers, and wish you well in the work you're doing in Victoria. Thank you very much.